J'appelle, je crois, Madame Michele Reed. Est-ce qu'elle est bien là? Non. Nous allons donc appeler Monsieur Antonio Rocco Congelosi. Si, Madame Reed, oui, bien sûr. For 5 minutes, please. Thanks a lot.
Good morning. I would like to thank His Majesty for organizing this conference and the opportunity for our exchanges. I'd like to thank the Minister of Justice, the Supreme Council, Judicial Council, and the Office of the Prosecutor for hosting the conference, and the Secretary General for extending a genuine welcome to us. I'd also like to express my appreciation to Jeffrey Apperson of the National Center of State Courts and his staff for coordinating my attendance. My participation is on behalf of the Director of the Administrative Office of the United States Federal Courts, Mr. James Duff, who serves at the pleasure of the Chief Justice of the United States Supreme Court, and also on behalf of Judge Allison Duncan, who presides over the Judicial Conference Committee on International Judicial Relations. In response to the introductory question, in terms of addressing judicial ethics, is it sufficient to rely on personal responsibility and commitment, or is it necessary to have a formal process and regulation? In the United States, we have found that both are necessary. An essential pillar of judicial independence in the United States is the confidence of the public, including public officials, and the integrity of the federal judiciary. This is particularly important because most of our federal judges are appointed to serve for a term of life, and they may be removed from office only for cause through an impeachment process. To establish and maintain the public trust, the judiciary imposes a number of accountability instruments on federal judges. Some of these instruments are formal: the Code of Conduct, several federal laws related to gift acceptance, limits on incomes that judges can earn from teaching or publishing, the only permissible outside income activities they may engage in, and laws related to disclosing their financial holdings. Additionally, we have several annual reporting requirements on financial matters, gift acceptance, and reimbursements that are collected by the administrative office. Our Code of Conduct provides guidance for judges related to financial and relationship disclosures, so to avoid compromising the integrity of the office and to give a judge guidance on when he or she should recuse and not preside over a particular matter. Compliance with the code is self-governing. Judges are expected to be familiar with its canons and to know when to seek additional guidance. To assist judges with this obligation, the Chief Justice of the Supreme Court has appointed a standing committee of judges who are available for formal and informal counsel and confidential advisory opinions. That committee is assisted by staff at the administrative office, who also serve as counsel and manage the publication and disclosure of opinions and other guidance. We also rely on several informal mechanisms to reinforce judicial integrity, such as counsel by the chief judge of the court in which the judge sits, the culture of the court as a body, and the expectations of the local community. The administrative office and the Federal Judicial Center, the education arm for the federal judiciary, also provide ongoing education to judges and their staffs on complying with the Code of Conduct and its related laws. This ongoing education is essential as changes in our lifestyles impact judges' compliance with the code. Through ongoing education, judges receive guidance on dealing with social media and limits on political participation, two matters which have become more significant recently. While the Code of Conduct is the vehicle for judges prescribing their own behaviors, we also have a system for attorneys and the public, including congressional members and other judges, to file complaints related to the conduct of judges and their continued ability to hold office. In 1980, Congress enacted the Judicial Conduct and Disability Act, which created a system for filing complaints against judges and for the discipline of judges, which may range anywhere from changing their caseload assignments to recommending removal of office. It is important to note that while Congress created the system, its implementation is vested within the judiciary itself. The separation between enacting the law and its implementation is essential to our notion of avoiding undue legislative interference on judicial independence. In administering the system of this review of complaints, the Chief Judge of each Court of Appeals and its related Judicial Council have significant responsibilities related to review and investigation of complaints, imposing discipline if deemed appropriate, and making appropriate reporting and disclosure requirements. If there is any concern that the judges within that jurisdiction are too familiar or unable to be objective in reviewing these complaints, there is the authority to appoint a special committee of judges from outside of that jurisdiction. Even with this formal process for reviewing complaints of misconduct or disability or inability to serve office, we continue to rely on informal systems to address a number of matters. We also have an ongoing system in place to educate chief judges on the process of conducting these reviews. The Chief Justice also has appointed another standing committee of judges to serve as counsel to the chief judges of the courts and the circuit councils in reviewing complaints and initiating investigation procedures. This committee also has the authority to initiate and review a complaint process. Additionally, the director of the administrative office must report to Congress annually the number of complaints filed and the actions taken on those complaints. Even with this intention, we have found in our judiciary that it has been necessary to review the implementation of the judicial review process periodically. A formal review was done in 2006 by a commission of judges appointed by the Chief Justice. As a result of that review, we learned that we need to do more to make the public aware of the complaint process, that we needed to decrease the time that it took us to engage in the investigation process when it was deemed appropriate, and that we needed to provide more detail to our reports to Congress. Making this commitment was important to, again, maintain our independence and our commitment to the integrity of the judiciary. And this year, the Chief Justice has appointed a working group to review specific matters that have been recently expressed as concerns by the public and judicial employees. In the initial phases of this review, an early disclosure has been that we need to distinguish between an employee's obligation to maintain the confidentiality of case matters as not precluding their ability to make disclosures related to concerns of judicial misconduct. We have found that ongoing and periodic review of our canons of the Code of Conduct and of the Conduct and Disability Review process are essential to maintaining the confidence of the public and judicial participants and our independence, as it demonstrates that our federal system continues to be a forum of integrity and fairness. Thank you.
Merci infiniment, Madame Reid, pour ce panorama complet des dispositifs, notamment légaux existants.